Today I want to talk about intellectual property. This intellectual property is actually very important, particularly when it has to do with our modern economy. And Nigeria is a very large country. We have a very big entertainment industry. We have the music industry, we have the Afrobeats, we have Nollywood, we have skit makers, we have a lot of creators in Nigeria. And they are doing very well, and they are even recognized globally. We have people like Burna Boy, Thames, Whiskey, and other Davido. These are artists that have won Grammys. So Nigeria is a very big country when it has to do with intellectual property. We have creators of in different industry. So it is important for Nigerians to understand what intellectual property means, and that is what I want to talk about today. First of all, what is this intellectual property, or in short called IP? Intellectual property simply means creations of the mind, which includes your songs, movies, videos, your logos, your designs, your inventions, etc. They are numerous. Your books, the songs that you write, they are all your intellectual property that you own. So intellectual property are the creations of the mind, and they are protected by the law. So it is not a right that you have that is not protected. It is rightly protected by the law. And we know that in Nigeria, our creative sector is very large, and people make a lot of money from their intellectual property. For instance, in 2024, Spotify released their updates concerning how much Nigerian artists made. They said that the Nigerian artists were paid about $56 million, which is very big. It's a very good amount of money. So if Spotify alone paid $56 million to artists, Nigerian artists, what about other platforms? We have Apple, we have YouTube, we have Audiomack, we have Play, we have different platforms that these artists upload their music. So you see that at the end of the day, these artists are making a whole lot of money. So the creative sector is very big. Even skip makers, they are making money. People are being paid by Facebook, Instagram, TikTok. So our creative sector is actually a very promising one, and it is very benefiting to our creators. So it is important for us to understand what intellectual property means in order to know how to protect our rights and also avoid violating the rights of others. So what are the types of intellectual property? We have different types. Number one is what we call the copyright. The copyright refers to the rights you have over your literary and artistic works, such as your books, your music, your videos, your advertising, your computer software, etc. They are your copyright works. And they are protected by the law. You have sole ownership over these rights. However, you have the right to give permission to another person to use it. That is what we call granting of license. You can grant license to another person to use your work. You can also assign it to another person to also use. That is, assignment basically means you are selling off the rights you have to another person. So it also occurs. Some people give out their rights, some also sell it and get royalty from it. So that is how it works. So when your copyright gives you exclusive ownership over your work, so no one else has the right to reproduce it or to broadcast it for any means except in a situation where you have granted the person permission, or in other exceptional situations, maybe under the fair usage, maybe the person is using your work for research and also need reference to you. So, but apart from that, no one has right to use your copyright without your consent or your permission. So, however, some people can also grant license to collective management companies to collect their royalties and manage the royalties for them, to manage their copyrights and pay them depending on the agreement they have with the collective management organizations. So number six, the second type of intellectual property we have is what we call the trademark. So what is this trademark? This trademark simply means the science that has the capacity of distinguishing your products or your services from other people's own. So it's more like what the science, the logos, or the things, the designs that you use on your products to distinguish it from other people's products. For instance, when you see a product of Nike, you will see the sign. When you see a product of Gucci, you also see the sign. They have different signs. So this signs actually enables people to know that yes, they are actually buying these products. I've seen situations where some people fraudulently they go and produce a goods and use the sign of an established brand to put on the product. So, and this is it's very wrong. It's an infringement of the trademark of the owners of the brand, because at the end of the day, you are deceiving people to buy your product. So another type of intellectual property that we have is what we call the industrial design. The industrial design simply means the design that you have for your goods, the physical features of your products, which is different from that of others. So it's actually basically the ornamental and the aesthetic features of your products, and this is peculiar to handmade goods such as cars, telephone, computer products, electronic products. Let me give you, for instance, when you see a design of a car produced by Toyota, it is different from the design of Honda. The physical features, the shape, they are different. When you see the design of Mercedes, it is also different from that of Toyota. So, industrial design has to do with the physical features, the shapes of the goods that you have. So, you have the right over your industrial design. That is how it works. So, another person cannot use your design and as its own. It doesn't work that way. It's a violation of your industrial design. So the fourth one we have is the patent. Patent refers the right you have over the invention that you made. So for you to enjoy the right to patent, it must be an invention. It must be either an invention, a patent to a new way of doing things, or a new technology of doing things. So it must be new. The invention has to be new for you to be qualified as a patent. And you have to register it in order to benefit to benefit your rights as a patent owner. So the fifth one we have is the geographical indication. The geographical indication actually refers to the signs on goods or products that have a specific geographical origin or process. So when these goods are produced, because they are from a particular geographical origin, they are not something that you see or are produced from different geographical origin, there is need to protect that reputation so that consumers will actually know that they are buying these goods and that these goods are actually from this particular place. So that standard from that particular place, it has to be retained. For instance, this the tequila liquor actually from Mexico, as it's originated from Mexico. So when you want to buy the tequila, there's a sign which shows that it is from this place. So that is what geographical indication means. The sign indicates that it is from this place. So it's also a form of intellectual property